break.
Party for McBride. Calling case 2400413, People versus Martell McBride. To hear for motion hand appearances, please.
Good morning, Your Honor. Andrew Tyler from People, P87431.
Good morning.
Morning, Adam. William Winters, P35975 on behalf of Mr. McBride.
Good morning. Good morning, Mr. McBride. Please state your name for the record, sir.
Martell McBride.
Thank you. We were here last May 15th, so last week, and we were here for an alleged tether violation. And we were adjourned briefly to get some updated information on the case that Mr. McBride has in another division of the circuit. I wasn't certain whether it was the domestic relations division or the juvenile court. Mr. Winters, can you confirm?
Here with the court commission. We're checking the judicial officer, but it's been adjourned until the 29th as an advisory.
I just wanted to know which court we're dealing with.
Understood this.
Did you go downtown?
No, I did. I went on Zoom. I was doing it on Zoom, but my judge, my lawyer, I'm sorry, she said that the judge never came into the.
Who is your judge?
Judge Cholak.
Okay, so that was in the domestic relations division. If you ever have to go in person, you wouldn't need to go downtown to formerly known city county building, now formerly known building, or even up to Print Court, but that's not what I'm dealing with you. I just wanted to be certain what type of case you were involved in so that I would know whether I needed to fashion your bond in a way that supports any orders from that court with respect to no contact in case you had a parenting time issue. Yeah, that's it. So we were here on a tether violation, and it was alleged that you went outside of your permitted zone. Mr. Winters, I don't believe that you were with Mr. McBride the last time. Mr. McBride told me that he left his restricted. He went outside of his restricted zone because he needed to go and get his children, and there was something about his children being left unattended.
Well, I'm sorry to interrupt you. I think the court is correct. I was here, and unfortunately, I got tied up later on in the morning, could not get back in time. But no, Mr. McBride indicated that, and it's consistent with what he told the court about the family court. The kids were in dire need, and he left with that explanation.
So that seems reasonable enough. I hope that it won't happen again, Mr. McBride, but if it does, you should contact your tether agent and let your tether agent know. And you have a telephone, right?
Yes.
So we'll keep the bond as it is. And
Your Honor, if I may just,
yes,
I have a few things. The reason that this came up was that our office got notified of this was that the victim called AP Wheeler, and she said she was upset. She said, "Why is the defendant? Why is he out? Why is he around? What's going on?" And AP Wheeler said, "Hey, this is not he's not house arrested. I don't think he's been violating." She said, "Well, she was going to a restaurant, and her sister was there, and her sister called and said, 'Don't come here. The guy who shot at you is here at the restaurant.'" AP Wheeler then reached out to the tether unit, and they produced this report. I also contacted the victim. She said the same thing to me. I asked for a little bit more information, but that was just a couple days ago, and I haven't gotten anything since. But from what I'm saying, that would be on April 27th. These violations in this report are the 29th and the 30th, and there are 3 separate violations here. Other factors, when the original incident happened, the defendant was on probation for a domestic violence conviction. A search warrant was produced based on this incident. A gun was found in his car, which because of probation he shouldn't have had. These different things.
You said a search warrant was produced because of the incident with
this case. Oh. Correct. Yep. But altogether, this gives a picture to the victim and the victim's family that Ms. McBride can disobey a court order and not have anything happen to him. They're understandably very concerned. They're understandably worried, and I think it makes sense that someone who shot at the victims, for her family, someone who shot at one of their family members, is disobeying a house arrest order, and they're understandably in a lot of fear as to what might happen to them because of that. So the people are asking that the type of privileges be revoked due to this and the other allegations.
Mr. Winters.
This is the first time hearing of anything like that. Now, if there was a police report, general.
Excuse me, Mr. Winters. Mr. McBride, your gesticulations, your sudden body moves, that's not helpful. It's not helpful to you. Please just be still. It's distracting. Thank you.
You can tell that Mr. McBride vigorously denies these allegations, and they're not consistent with the tether records. I don't know what the police report generated at all. And if the prosecution has evidence of a firearm that was conducted pursuant to a search warrant, then we'll delve into that a little bit more in detail.
That's in case policy starts with. It's not a separate thing.
I understand. I think that we probably need to have a hearing of we need to have a hearing. What Mr. McBride said happened is totally inconsistent with what the people are alleging. The truth is somewhere, and I need to find out what. So when should we come back? How long will it take for you to get your witnesses together?
I'm not sure.
3 weeks.
Well, keep in mind that the bond's not going to be changed until the hearing. So
if we set it up for a couple weeks, I can reach out to the bond unit and, if possible, move it up.
Okay, that sounds good. So what about then the 11th, the 10th and the 11th?
either work.
10th would be preferred. Your Honor.
Does that work?
Yes.
All right, so Mr. McBride, you're already on house arrest, so doesn't get more restricted than that unless you're in jail. And you're going to have a hearing on these allegations on the 10th of June. And if I were you, between now and then, I wouldn't even go out on my porch.
Good advice, Your Honor.
So I'll see everyone at 9 a.m. on June 10th.
Very well. Thank you again, Your Honor.
Thank you.
Party for record. Calling case 2300493, People versus Daniel Rucker, Junior for sentencing. Appearances, please.
Good morning, Your Honor. Assistant Prosecuting Attorney on the Council on behalf of People P87076.
Thank you.
And good morning, Your Honor. May I please call the court and your staff, Melvin Houston, number 36280. On behalf of Mr. Daniel James Rucker Jr., who's standing to my left, this is the date and time set for sentencing. Your Honor.
Good morning, Mr. Rucker. Please state your name.
Good morning, Your Honor. Sorry about the alarm. My name is Daniel James Rucker Jr.
You're here for sentencing? Excuse me.
That is correct, Your Honor. The defense has had an opportunity to go over the pre-sentence report with Mr. Rucker, and there are no changes that need to be brought to the court's attention regarding that document. Also, we reviewed the sentence information report and then also scored correctly. So, on behalf of my client, I would just say, this is an experience for him. You know, he inherited a lot of weapons from his father who died about 2 years ago. So, with all that being dropped on, he really wasn't familiar with the rules and regulations about gun ownership. But I think he's a little bit more aware of it now, given the events in both this case and the other case that was a companion case to this one. And I think he fully intends to turn his life around. He doesn't have a choice. He has 8 children. And it's time for him to start thinking about them, you know, a little less about himself. And I think he understands that. At least I hope and pray that that's how it goes.
Excuse me, speaking of the other case that was incorporated in the plea agreement.
No, that was a dismissal, as the court may recall. The complaining witness failed to appear.
I didn't recall, but thank you.
And this case was held in advance pending the results of that case, which included some much more serious charges. All these assaults, that was felony firearm, and it was a much more serious case. So the prosecution took advantage of the fact that this case was still pending, and my client really had no, I mean, the videos, what have you, really wasn't accept terms.
Yes, Your Honor. So the law also reveals the pre-sentence investigation report. There are no additions, deletions, or corrections to be added. People has to be applied by sentence.
Mr. Rucker, is there anything you'd like to say before we close this?
I really did learn my lesson as far as getting my life together. Before this situation in the previous case, before I was already in pursuit of doing that. I was already acquired my license. When I acquired my license, I originally thought I took care of all my tickets, but I kind of when the PSI when
This is a pre-sentence
right, when the PSI came out and I seen that I had 7 other tickets that I didn't know about. I was if I didn't know about it, then I would have took care of it. Like I said, up until now, I didn't have any other cases or pending cases. In the cases that I still have is 10+ years ago. Like I said, if I didn't know about it when I took care of all my other tickets before I got my license, I would have took care of the ticket then. But now that I know about the ticket, it will be getting taken care of.
All right, is there anything else? Not that any speakers.
No, ma'am. No, ma'am.
So I read the report, and it's a little unusual in that most of the time when I see the kinds of charges, and especially the sentencing charge when you're dealing with guns and violent behavior, I know that the other case was dismissed, the assault was when I see those kinds of charges, I don't usually see that with the kind of other facts that describe your life, or that other facts that are a part of your life, like being gainfully employed and having a business. And although you didn't graduate from high school, you finished the 11th grade. And do you have a certification with respect to high-low driving?
Yes, I have certifications for
I know that, excuse me, you established a business, which has allowed you to be gainfully employed, rather than just working a job. And as Mr. Houston said, you have 8 children. And I know that you don't have the same relationship with all of them, but what I'd like for you to consider, Mr. Rucker, is what those children are going to think, not just about you, but about themselves, if when they get older, they discover that they have a father out there who didn't have any contact with them. What very likely would happen is that they will, in pursuit of acceptance and in pursuit of acceptance, they'll associate themselves with bad people and very likely get into crime. So I would ask you to consider your lack of relationship with these children. I know you're probably thinking, what does that have to do with this?
No, I get exactly where you're coming from, John.
Well, what I try really hard to do is stop chains, negative chains, break negative chains, I should say, if I can. And I don't want to see any of your children before me or another thug at some point because they didn't have a father in their lives who was trying to point them in the right direction. The fact that you have a criminal history can actually be helpful to them because they can see that you can overcome it, and they can see that the best way to go about life is to say, "Oh, thank you." That's just my 2 cents, maybe 5 cents. I am pleased with that the agreement they made with people, and that is to impose 12 months probation, and that would be $30 per month for supervision, so that's going to be $360 in supervision costs. Court costs of $1,300. Attorney's fees are $400, although that doesn't actually reflect the amount of work and time that attorneys put into cases. It's just the standard $400 that we post. I'm sure you'll agree that it doesn't reflect the quality of the representation that you have. But I'll waive that because you have 8 children.
Thank you so much,
Hoping
John.
that saving some money will allow you to spend it on it.
Thank you so much, John.
And there's a crime victims assessment of $130, state felony cost of $68. And there is one other thing I wanted to say. I noticed that although you've certainly been staying out of trouble, I noticed that most of your cases involve what the kinds of cases that we see will be past substance issues. And you reported that you smoke marijuana, it's legal, you're an adult, and you seem to be staying away from getting in trouble with substance abuse. But I think that may have something to do with all of those fleeing and looting and other driving related offenses. Another 2 cents. So I think that you know.
I think you only get 130.
Very good. Cool.
I think there was one other.
Attorney fees. So court costs of $1,300 and rate attorney fee, crime victims assessment $130, $68 for state felony count, and $360 for probation. So, Mr. Robert, if you disagree with your conviction or sentence or both, you would need to file a claim with the Court of Appeals within 42 days asking for leave to appeal. If you need the assistance of a lawyer to do that, if you can't afford it, then you'll need to contact this court within 42 days and report a lawyer. And I wish you the best. I hope I won't see you again.
Thank you, Ron. You have a good day.
For his sake, I hope so, Your Honor.
I appreciate all the sense. I appreciate all that.
Mr. Rudd, you're going to receive some appellate rights.
Yes, I got it.
Oh, is that okay?
Yeah.
Well, he's trying to get out of here.
Yes. You can go to probation now.
Okay, thank you. Have a good one.
Thank you.
Sorry, take care.
Party for Pavone. Calling case 2-004436, People versus James Malone. We're here for a final conference. Appearances, please.
Good morning, Your Honor. Amy Tyler for the people, P87431.
Good morning, Your Honor. Mark Teklinski on behalf of Mr. James Mabon.
Good morning. Good morning, Mr. McCall. Please state your name for the record.
That's my mom.
Here. Or. Yes, I understand that there's some. Is that right, sir?
That's what I understood as well, Your Honor. I don't have a physical plea form. I have it's a very old case, so the file I just have the note that says what the offer was.
Okay.
So I wasn't sure if that was what was going on here. Mr. Teklinski said that he had it, so if he doesn't, it's signed.
Mr. McCall, have you signed? Mr. Teklinski?
Yes, Your Honor.
Do you have a plea form?
Yes, Your Honor. We have a proposed resolution.
All right, let me try it this way. What's the offer? One moment, Mr. Teklinski.
Yes, Your Honor.
So the note that I have here, Your Honor, is we would reduce it to receiving and stealing stolen property less than $1,000 if Mr. Ramon would pay restitution of $5,336 on the day of sentence.
5,000.
336. Yep. and then we would offer 1 year probation.
Did you hear that, Mr. Teklinski?
I did, Your Honor.
All right, have you had an opportunity to speak to Mr. Maybone about that offer?
Your Honor, we accept that proposition and ask the court to adopt it.
Mr. Teklinski, have you spoken yet with Mr. Maybone about that offer?
I have had the opportunity to do so, Your Honor. He understands that.
Okay. Is that right?
He has spoken, said no restitution.
Mr. Maybone, Mr. Maybone said he didn't discuss the restitution provision with you. Do you want to have an opportunity to talk to him about that?
Your Honor, we have discussed that matter, and indication is that the complaining source is no longer in business, so we would ask this court to waive that restitution section, if possible.
Well, I can't waive it because that's a part of the negotiation. I can reject it if I can reject the settlement agreement if I don't agree with it, but I can't be involved in the negotiation itself. That's what the people have offered. They've offered $5,336 in restitution. That's part of their plea and sentence agreement.
Your Honor,
yes, sir.
it is my understanding that the business is no longer operating, and we wouldn't know who even to make that payment for the restitution if the court would rule.
Yes, I understand, but it's not anything that the court can do anything about. It may very well be that there are some errors in interest. I'm probably not using the proper terminology, but just because the business is no longer in existence doesn't mean that there aren't people associated with that business who might have a right to restitution. I don't know. I have no idea. But I do know that this restitution amount is what the people are requiring for the plea agreement.
The proposed resolution by the prosecuting attorney said, Your Honor, she will remove the restitution requirement if the business is no longer operating.
Well, have you spoken to anyone in the prosecutor's office supervision?
I have a written proposal, Your Honor, from the prosecution, which states I need to confirm whether the business, where the cash, the fake check is still in business. If it is no longer in business, I think I will remove the restitution requirement.
Okay, so who said that, sir?
This is by the prosecuting attorney, McKinsey Wheeler.
Oh, Mr. Wheeler. Okay, so we have Mr. Tyler now. He's Mr. Wheeler's successor. But Mr. Tyler, can you confirm with whatever personnel would be necessary of whether that restitution amount can be modified or eliminated in that the business is no longer in existence?
Yes, I can do that.
Okay. Do you think you can do it today, like within the next 30 minutes?
I can try to.
Okay, because I would like to resolve this today if I can. Mr. Maybone's here in person, so let's see if we can do that. Mr. Teklinski, we're going to take a break so that Mr. Tyler can with supervision about whether that provision can be removed from the offer, the restitution provision. So we're going to go off the record for a short while. Please just.
Your Honor, I am at your command, Your Honor.
Thank you. You all didn't hear that. Thank you. Thank you, Mr. Tyler. I think this one here doesn't have restitution, just have reduced charge and basically
I'll send him a text message around
Okay.
if that is.
well, he can confirm that. Yes, we found the plea form.
Oh.
Do you want to confirm? Or are you good?
Confirm. There aren't any terms.
Yeah, there's no terms, so I want to talk about
Oh, I didn't know.
It's okay, yeah.
I was just looking at restitution.
this. Yeah, let me still.
Sorry, it's exercise. Yeah. Going back and forth.
Okay. Parties was allowed. Calling case 24001432, People versus Ahmed Salah. We're here for a final conference. Appearances, please.
Morning, Your Honor. Is this prosecuting attorney on behalf of the people P 87076?
Right.
Good morning, Your Honor. Mark Carter,
Good morning, sir. And good morning to you, Mr. South.
Good morning.
Please say your name for the record.
Solid.
Thank you. So we're here for final conference, and I don't see any outstanding motions, so we have a trial date for July 8th. Are we going to try
No, Your Honor, so this likely ask this honorable court to discuss the case without prejudice.
to discuss the case without prejudice? No, sure. I need to inquire because it is supposed to provide to. That's all, Mr. South. Nice to meet you. You're free to talk.
Thank you. Thank you, Judge. The regional, no,
Oh.
no,
No, I'm just joking.
not with the, sorry, no.
No, not for the road, but you gave me, yes, okay, that's good, no, I'm good.
And I have this,
Could you see you again soon, okay? Thank you. Drive carefully.
Meaning,
good morning, Mr. Marshall.
Judge.
We're waiting for APA Decker. Mr. Coombs is going to see if he can track him down, but where is Mr. Thompson?
He's in the waiting room.
Oh, he's Moto G. Can you confirm that we've had a lot with Zoom, and I don't want to let him in without confirming. We did send a message. I guess he didn't get it, asking him to rename his device, so we would be able to identify him. I think that's what's by itself.
No, that's somebody's name. That's like,
No. Did you hear me, Mr. Marshall? Can you get him to change the name on his device?
I can try.
Okay.
Send her a text.
Or just confirm that he's in there under Moto G Power. Thank you.
Judge, you said it's under Metro PC Moto. You're muted, Judge.
Thank you.
That was-
There he is.
Yes. Oh, good morning, Mr. Thompson. We were trying to confirm who you are. We can't let people into the Zoom courtroom unless we can identify you. So next time, please change your name on your device so we'll know who you are, okay? Mr. Thompson, did you hear me?
I can hear it now.
Okay, I was just saying, we kind of took a chance that you are who you are, but by letting you in from the waiting room, but we're not supposed to let in people whose devices don't identify them. Yours says Moto G Power. So when you come back next time, please change the name on your device so we'll know who you are and can admit you into the hearing room, okay?
Yes, ma'am.
All right, Mr. Jackson. Nice to see you.
Nice to see you too, Ron.
Okay.
Yeah.
I think it's-
Calling case 240000221, People versus Lateef Thompson. We're here for final conference motion hearing. Appearances, please.
Good morning, Your Honor. Dr. PA 5931 for the people.
Good morning.
And good morning, Your Honor. This is the prosecuting attorney on counsel on behalf of the people. I'll be handling the case ending in 7492.
Thank you. We didn't call that one, but we'll just go ahead and call it.
22092.
So I entered a tracking for in the case ending in 7492. So it's going to track this case ending in 221. And a couple questions, well, one question preliminarily before I entertain argument on these motions. Do we have two outstanding or one? I think we have a motion to quash, but I also thought I saw another motion in the file.
Judge, what happened? I filed a motion to quash on the 221 or 1 FH case, and MI file kept rejecting it. So it was sent in 3 different portions. It's hard to understand the original motion and then the supporting law in support of the motion, and then getting into the meat and substance of the transcript and the arguments as to why it should not be bound over. I just got a rejection notice, and I don't think the prosecutor got the rejection of the argument regarding the specifics of the transcript, which are the most important portion of that, and I don't think the court has that either.
Okay, well, I'll tell you what I do have. I have defendant's motion to quash, bind over, and dismiss information that's dated April 1st. I have the brief in support, which is dated, that's also dated April 1st, and I have the preliminary exam transcript. And the preliminary exam transcript is in Odyssey under people's response, but I don't know if the people filed the transcript or if it was erroneously captioned, but that's where the transcript is, under people's response, which I think was.
You're on the first page of first 2 pages, I believe, of the people's response. Because what I did is I did the people's response to the motion to quash, and I attached the exam transcript to it.
Oh, it only shows the exam transcript.
I'm right.
Right. So what the court
is
does
the
not.
last 2 pages, maybe?
Well, I'm looking at that's possible.
Sometimes that
Yeah,
happens.
that's exactly what it is.
Oh, so because I specifically thought I fixed that.
No, I should have gone to the bottom of the document. Okay, let's see. This is 53 pages. So okay, just give me one moment, gentlemen.
I can summarize.
I'm trying to stop this.
Well, Judge, there was a supplemental brief that was filed addressing the preliminary exam transcript, going into the heart of the matter and why there should
No, I
not be
don't
bound
have
over.
that.
Right, you don't have that,
something.
and I don't think that Mr. Decker has that either.
Okay.
Because it was
How soon can we get?
well, I filed it and it was rejected. I can
So
file
let's
it
do
again.
this. Can you email it to us?
Yeah,
Your
I
Honor,
can do that.
is it possible we can just summarize it and maybe argue this over with oral arguments?
Well, that's what I was going to do.
Okay.
Entertain oral argument, but I still need the supplemental brief. Do you want to just go ahead and proceed, and then we'll get the hard copies of the supplemental brief later? I promise I'll read it.
Yeah, or we could set it over for another day.
Okay, if you prefer to do that, that's fine. So then you're going to email Mr. Decker and court, right?
Right.
The supplemental brief. Okay, and when should we come back, Mr. Decker?
This week, are we thinking this week, Your Honor?
I think this week's good for me.
Okay. I am fairly free on Thursday. Friday's a little bit more busy, although I'm here for I see I have a 1 o'clock here scheduled with in a different matter here in this court, on Friday.
On Friday.
Do you have that also at 1 o'clock?
Let's see.
It'd be for defense last name is Cohen. Oh. Write those down.
Okay, well, we'll deal with that in a moment.
Okay.
Then.
So do you just want to say Friday, Your Honor?
Yes.
Okay. Does that work in counsel?
Yes, what time?
So let's make it Friday at, we have one at 12:30. Let's make
I'm
it
sorry?
Friday.
1:30 it is.
1:30?
Yes, 1 or 1:30, whichever is
Yeah, 1, sooner the better. I don't want to cut into your lunchtime though.
lunch. What is that? What is that?
That's the bag of Cheetos under the bench there.
Yes, that's what it is. That's exactly what it is. So we'll see you all at 1 o'clock on Friday, the 24th.
Okay, thank you, Your Honor.
Okay, thank you.
Mr. Marshall, can you send it to the Judge Green Court email?
Yes,
Okay.
and directly to Mr. Decker. I'll do both.
Yes, thank you.
Attorney Brown finally sent.
I appreciate it. Yeah, no, it's down to 2 bills.
Yeah, I know you're over there.
I'm not over there anymore. Only
Oh, okay, there you go.
I just made a reference.
Yeah.
Thanks, Mr. Marshall. See you Friday.
Thank you, Friday.
Okay, what's the verdict, Mr. Tyler?
Spoke to back attorney Mahmood and also to AP Wheeler, and both, I guess neither said that we were willing to give it a restitution completely. If we did a restitution to be determined, because the company is out of business. But restitution to be determined and then bring in our claim witness who has been talked to recently, it's a real case, but last month he was talked to. So that could be a way of moving forward, but getting rid of restitution completely is not something.
Okay. Mr. Cheglinski? I don't know if you heard all of that. Mr. Thompson, I'm so sorry.
Yes,
We're off the record with your case. We're going to return on Friday because your lawyer tried to file something on your behalf that was rejected by our automated system. So we're going to come back on Friday for your matter and hear your motion. That's going to be at 1 o'clock.
okay, so just zoom back in?
Yes, but remember to change your name on your device so we'll know who you are.
Yes, ma'am.
Okay, we'll see you Friday at 1. Thank you.
Okay, thank you.
You're welcome. Mr. Cheglinski? You're still muted, sir.
I am here, Your Honor.
Thank you. So Mr. Tyler conferred with supervision in the prosecutor's office, and they're not willing to eliminate the restitution provision, but they're willing to proceed by having restitution to be determined. And I could put a stipulation in the, I could put a stipulation that it be determined within 30 days of sentencing, but we're not at sentencing.
I understand, Your Honor, your instructions now. Would the court allow me a minute or so to convey that to Mr. Mabone, please?
Well, I would, but Mr. Mabone doesn't have a cell phone with him, so he can't join you in the waiting room. But Mr. Mabone is right here in the courtroom, and he's heard everything. Mr. Mabone, you can put your name back. We're not on the record, actually. So let me call the case. One moment. You can come on up, though, Mr. Mabone.
Recalling case 2100446, People versus James Mabone. We're here for the final conferences. Appearances, please.
Good morning, Your Honor. Andrew Tyler for the people, P87431.
Good morning, Your Honor. Mark Teklinski on behalf of Mr. James Mabone, who stands in front of the court on the podium.
Thank you.
Guys, maybe over here.
Thank you. So we had a brief off-the-record discussion, Mr. Teklinski. We're back on the record now, obviously. And what I was saying is that the people are not willing to withdraw the stipulation for restitution. But excuse me. I'm so sorry. Excuse me. The people are willing to have the restitution term be determined, and at sentencing, I would indicate the restitution needs to be determined within 30 days or forfeited. And so that would give us between now and the date of sentencing to know whether anybody's going. That would give us between now and 30 days after sentencing, I should say, to know whether restitution is going to be involved. But there's no way for us to know for certain before then unless we have a restitution hearing.
Your Honor, I understand as the court has enunciated regarding the restitution. I would like the honorable court to question Mr. Mabone whether he understands that.
All right, thank you. Mr. McCall, do you understand what I just said? He's indicating yes. So just to be certain, the The offer is for. Did I see that, Mr. Boss? One moment. Oh, this is very strange. So the offer is for him to plead to the reduced charge of receiving and concealing stolen property less than $1,000 and 1 year of probation and restitution to be determined. Mr. Maybone, do you understand the offer?
Yes, I do.
And do you want to enter into that offer, that agreement today?
Yes.
All right, we need, I'm going to modify Mr. Tyler this plea form.
Okay.
Actually says no service agreements under change to service agreement. To 1 year. Probation. Restitution. The determined within 30 days of sentencing. Now, we do know that there's going to be some money owed to someone, Mr. Mako. So on the date of sentencing, realistically, how much money can you bring to pay on this?
30 days later.
No, on the date of sentencing, how much money can you bring to pay on this? Well, we don't know yet, but it's going to be within the next 3 weeks. It's going to be 4 weeks.
I have $300.
Okay, so I have to bring $300 just to be sure. On the date of sentencing. Okay, so Mr. Teklinski, I have modified the plea form to include 1 year probation, restitution to be determined within 30 days of sentencing. And I'm going to advise Mr. Maybone now. Is that okay with you?
Thank you, Your Honor.
All right. So, Mr. Maybone, this document is something that you need to execute. Mr. Maybone is going to sign the plea form, Mr. Teklinski.
Pardon me, Your Honor.
Mr. Maybone is signing the plea form.
He has not done so in my presence, Your Honor. I do not have the plea form.
Oh, I understand. I said he is signing it now. He's signing
Your
it.
Honor.
Okay, Mr. Teklinski, I don't know if you can see this, but he is signing the plea form.
I rely on the court that he has.
Okay. All right, Mr. Maybone, I have this document here, summon off advice of rights notice of acceptance. Do you see it here? Yes?
Yes.
Is it your signature here at the bottom?
Yes, it is.
So this document tells me that you've reached an agreement with the people, whereby in exchange for your plea to the reduced charge, count 1, receiving and concealing stolen property valued at $200 but less than $1,000, which is a 1 year maximum penalty. That was a felony or misdemeanor?
It is a 1 year. It's a 1. Forgive me, Your Honor. It is a 1 year.
But is it a felony or misdemeanor?
Let me double check, Your Honor. I will say I believe it's a misdemeanor, but
I think it is too. I think it's a high misdemeanor, but the important part is that it is 1 year maximum penalty. And you also agree to a sentence of 1 year probation with restitution to be determined within 30 days of sentencing. Is that your understanding of the agreement, Mr. Maybone?
Yes, it is.
Did you want to enter into the agreement now? So before I can allow you to do that, I have to be assured that you know the trial rights that you're waiving. These are constitutional in nature. So if there's anything you don't understand, just let me know and I'll explain it until you understand. You have an absolute right to a trial in this matter. That trial would be either before a jury, which would be comprised of at least 12 people from the community, please say those. Or it would be before a judge sitting alone, probably me, if you and the people agreed to that. But because of this agreement that you're entering with the people based on a guilty plea, you are waiving the right to trial. There would be no trial. Do you understand? Yes? You have to say yes or no. This is being recorded. And if you were to have a trial in this matter, you'll be presumed innocent unless the people prove you guilty beyond a reasonable doubt. But by entering into this agreement with the people today, you're also waiving that right to the presumption of innocence at trial unless the people prove you guilty beyond a reasonable doubt. Do you understand?
Yes, ma'am.
Additionally, if you were to have a trial in this matter, you have the absolute right to remain silent. Your silence would not and could not be used against you. But by entering into this agreement today with the people, you're also waiving that right to remain silent at trial, not have it used against you. Understand?
Yes, ma'am.
Additionally, if you were to have a trial, you would have the right to waive your right to remain silent and you could testify on your own behalf. And no one could prevent you from doing that, not your lawyer, Mr. Teklinski, or even the court. But by entering into this agreement, you also waive that right to testify on your own behalf, tell your side of the story at trial. Do you understand?
Yes, ma'am.
Further, if you were to have a trial in this matter, you have the right to confront each and every witness whom the people agree to testify against you. That would be through the process of cross-examination conducted by Mr. Techlinski, your attorney. But by entering into this agreement today, you're also waiving that right to confront any witnesses whom the people agree to testify against you at trial. Understand?
Yes, ma'am.
Also, if you were to have a trial, you bring witnesses to testify on your behalf. And if they wouldn't come willingly, court would order them to come through a subpoena file. But by entering into this agreement today with the people, you're also waiving that right to bring witnesses to testify on your behalf at trial. Do you understand?
Yes, ma'am.
And finally, Mr. Rainbow, by entering into this agreement today, based on your guilty plea, you are waiving or giving up the right to demand that court of appeals reviews your conviction, your sentence, or both. If you decide to change your mind about all of this later, you would have to ask the court of appeals for permission or leave to appeal, and they could grant your request or they could deny it. Do you understand?
Yes, ma'am.
Satisfied with the advice of rights counsel?
Yes, ma'am.
Mr. Techlinski, are you satisfied with the advice of rights, sir?
Yes, we do, Your Honor.
And do either of you counsel know of any inducement for Mr. Maybold's plea today that has not yet been placed on this record?
No, Your Honor.
None, Your Honor.
Thank you. All right, Mr. Maybold, will you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth?
Yes, I do.
Thank you. You can lower your hand. Mr. Tyler's going to ask you some questions. Please just answer them directly.
And Mr. Ramon, I'd like to refer your attention back to May 16th of 2015. On that date, were you in the area 5038 McDougal in the city of Detroit in County Wayne?
Yes.
And on that date, did you provide a false check?
Yes.
And you did that check was false, correct?
Yes.
And you did so with the intent to defraud?
Yes.
The defense answer.
Are you
We are
satisfied?
satisfied, Your Honor.
All right. Of course, satisfied as well. Factual basis. Madam Clerk, when are we coming back?
Okay. June 20.
Does June 25th work for everyone? 9 a.m.
Work with me?
All right. Does it work for you, Mr. Techlinski? June 25th, 9 a.m.
Yes.
Yes, Your Honor.
All right, thank you. We'll see everyone June 25th at 9 a.m. Mr. Maple, I'm going to put a right phone number down for you to the probation department. You will need to contact them immediately, set up an interview, which the pre-sentence report that the court will receive to inform it concerning your sentencing. That's going to be included in that report, so it's important that you make your appointment once it's scheduled. And if you cannot make it, be sure to let Mr. Techlinski know. So the phone number is 313-224-2600. Today, I'm going to hand it to you.
I have one question. I got this. I stay on telling to my sentencing.
Well, what do you think about that, Mr. Tyler?
He's showing up here now 2 days in a row. I would have no objection to remove the tether.
I'll remove the tether. I think it's reasonable under the circumstances. You're being sentenced to probation, and as Mr. Tyler said, you have shown up twice in as many days. However, you and I both know that you can keep your word with me concerning this tether.
Never, like I was saying yesterday, like, let me talk now. You're right. When I got out on that Friday, so I got home about 8 o'clock Friday night. You see it? I remember immediately report to, and when I went to the Kelly bag on Dickerson, they was closed Saturday or Sunday, so I had to wait. Now, you did say something about, well, you could have called in court, but I didn't think that. I'm like, I ain't closed. I just waited for Monday.
All right. Thank you. Here's the probation number. We'll remove the tether. So we'll see everyone on June 25th at 9 a.m.
All right.
Thank you. Thank you.
Thank you very much, Your Honor. Thank you. We'll see you on June 26th.
Thank you, Mr. Techlinski. We'll see you then, sir.
It'll be my pleasure, Your Honor. Thank you, Mr. Prosecutor, too.
I will. I will.
All right.
Thank you, Mr. Techlinski.
We worked hard on this case.
Thank you, Mr. Techlinski. You take care of yourself, sir, okay?
Always a pleasure, Judge.
You too. We'll see you next time.
Thank you.